Hey everybody, John Skiba here, and welcome to Thursday night. Hello everyone, welcome to the Consumer Warrior YouTube channel. John Skiba here, and I'm founder of the Consumer Warrior YouTube channel all those many years ago. And we're back here on a Thursday night like we are each and every week, where I do a live Q&A to discuss all things debt related. We talk about debt collection lawsuits, bankruptcy, credit reporting, all those kind of things, and I actually answer your questions. So if you are on the YouTube platform watching this, you can actually go there while we do this every night, every Thursday night at 5:15 p.m. I believe we're in, I don't know. I think we're in Mountain Standard Time. Arizona doesn't change with daylight savings, so it's always a kind of tricky as far as what we're actually on. But you can go there, put the questions in. The way we do it is I put it up here on the screen, and we'll actually talk about it. And so I do give the disclaimer, while I am a licensed attorney in the state of Arizona, I'm not licensed anywhere else. And you should not take any of this as legal advice. This is some dude just yakking on YouTube. And so if you need legal advice, I highly recommend you contact someone in your particular state. If you're in the state of Arizona, I do free consultations for Arizona residents. My information's below. I'm happy to talk with you and see what we can do to help you with your situation. So, in getting ready tonight, I was going through some of the comments over on the channel, and it would, I was looking at a question, or let me see here. Someone posted, I thought it was an interesting one. They said, what do you do if you have a default judgment from 7 years ago that you just found out about via the underwriting process while trying to get a mortgage, and you can't get hold of the original creditor? This is an interesting scenario, and it happens more than you would think. And it happened on a pretty big scale a while back with one of the junk debt buyers named Cash LLC. CACH was their name, Cash LLC. Cash LLC filed for bankruptcy protection. So kind of, they're a junk debt buyer. They go out, they file all these lawsuits, but they end up having to file for bankruptcy. A bankruptcy trustee steps in and then actually took all of Cash's assets and sold them to a company called Resurgent. And so a lot of people are in this situation where there were these old Cash LLC default judgments that they were dealing with, and they really couldn't really do anything with them. They couldn't get rid of them. There wasn't another party to engage with to try to settle it. And so this question came up as far as, what do? You're here like this person trying to buy a loan. Here's this old default judgment that pops up on a title search, and they're wanting you to resolve it, but you can't even find anybody to engage with. So what do you do? The options are somewhat limited, and some of them just may be requiring showing the mortgage lender that you've done your due diligence, you've tried to deal with this, and you just can't get anybody to connect with you. The first thing is, if it's a judgment, look at the judgment, because there will be a law office associated with it. In the upper left-hand corner of the judgment, they're required to put their contact information. That's the first place I always start, is reaching out to the law firm, trying to get their information, and maybe they can help you find someone to connect with. Now with Cash, we would call the lawyers and then be like, we don't represent them anymore. They're gone. They've closed down. And so that wasn't a big help, but sometimes that is. That's usually the first place I start, is contacting the law office, because they often will at least have some information as far as what you can do. Then you can, just do your own detective work to find, a collection agency, find who they are, to see if you can get it resolved. Worst case scenario, you can do a couple things. One is you can raise an objection on your credit report. Actually go to TransUnion, Equifax, Experian, raise an objection if it's still showing up there. They have 30 days to respond to it, to substantiate the debt. And if they don't do it, if they're out of business, they won't do it. Then they'll remove it from your credit report. With the title search, though, it's a little bit different, because they're likely finding a judgment out there. You could go into the court there and file a motion to vacate it. I have in my tutorials here, there's a link there in the YouTube, in the chat section, to the Consumer Warrior University. There's a template and a tutorial on how to do a motion to vacate, and then you could get it thrown out, because they're not going to respond to that either. So that can be a tricky situation when they get their judgment. Basically, they cause all this damage, and then they go out of business, and then there's not a lot. It's hard when there's no one to negotiate with. So that's something to take a look at. So, all right. So if you do have questions, and I am going to tell everybody I am a little bit limited on time tonight, and by a little bit of quite a bit. So I'll do as many questions as I can, but I'm probably going to have to jump out soon. But hey, Al, thank you as always for being here and supporting the channel. I appreciate it. All right, let's see here. Let's see what Chloe has to say. Chloe says, what happens when you don't have any exemptions and you're sued by a debt collector for $1,000, for example? But at the time of the judgment, you only have $300 in your bank account. So if they get a judgment against you for $1,000, the judgment is, I mean, the kind of the low-hanging fruit for collection attorneys and collection agents is wage garnishment and bank levy. Now, if you keep the amount of money in your bank accounts below what the exemption is, and each state has some exemptions. In Arizona, it's kind of crazy. It went from $300 for an individual up to $5,000. They passed this new Proposition 209 in November in the election. And so $5,000 can be considered exempt in the account. So as long as you're keeping that amount of money, the exempt amount or less in the account, then there's not a whole lot they can do. Even if they served a writ of garnishment on your bank account, they wouldn't be able to take anything out because the bank would recognize there's an exemption there. Now, if you don't have any exemptions for whatever reason, let's say your state just doesn't have an exemption, then it's a situation where you can, if there's no exemptions, then they can serve the levy on there. They can take the money that's in there and then they transfer it over to the thing. So, all right. I got my man Clint Goodman here, who I used to work with here at Jackson White alum, great attorney. He says Prop 209 sinks wage garnishment and bank levies. It does. It makes them a whole lot more difficult to accomplish. Excuse me. All right, let's see here. Let's see what G to the M says. Hello, I just purchased one of your courses to answer the debt summons. Thank you for doing that. I just filed the court, issued a motion to issue to compel. Just filed with the court, issued a compel of the arbitration agreement and waiting for an answer. Great. I appreciate you tuning back in and let us know how that plays out for you. We've seen some pretty good success with that. So, all right. We will. Let's see here. I want to thank Randall for checking in. Randall, big supporter of the channel. I appreciate you being here and all the support you do. Clint says, how does Prop 209 come into play, in your opinion? Prop 209 has been this interesting proposition in Arizona. It was something that was on the ballot. It changed. It was interesting because of the way it came about. It was billed as this way to reduce medical collections, and they kind of framed it as that, but it dramatically changed most of the exemptions in the state of Arizona. Like the homestead exemption went from $250,000 of equity being protected up to $400,000. Like I said, the bank accounts went from $300,000 to $5,000. Vehicle exemption went from $6,000 to $15,000. And not only that, it made wage garnishment much more difficult because it limited the amount. One, it took it down to, I believe it's 10% of your wages can be garnished, from before it was 25. And not only that, those who are eligible to protect all of their wages through wage garnishment, it made it much more difficult. So the issue that has come up is, as soon as it became effective, Prop 209 became effective on December 7th of 2022. Immediately, the creditors bar filed lawsuit against it, saying that it was unconstitutional. So far, I mean, the Superior Court said no, even though it's kind of wonky and hard to work through, it doesn't mean it isn't constitutional. They've appealed that, and now it's at the Arizona Supreme Court. So we'll see what happens with it. But the problem with what's happened is it's put a lot of kind of gray area, and it's put us in a situation where is particularly in the bankruptcy realm, there's a question sometimes as far as which exemptions are going to apply, because the creditors are trying to say that it's only applies to debts that were incurred after December 7th, 2022, which is the enactment date. And other people like myself say, no, that's ridiculous. Then you're going to have an exemption that protects some debts some way and other debts another way, and it's just unworkable. So I can tell you, in the bankruptcy realm, we have been using the new exemptions since January 1st. I haven't had any pushback from them. So I don't know if that's just luck of the draw or what it is, but I haven't seen them push back at all. So, all right, let's see what Ryan has to say. Ryan says, I owe Chase Bank $10,000. They sent to collections, but were unable to collect from me. Now Chase sent me a letter saying to settle for $1,500, but the small print said, we can't sue you because it's been more than 5 years. Okay, so Question here, Ryan, is should I pay or ignore them? So what this is there's this law called the Fair Debt Collection Practices Act, the FDCPA, and it states if a debt is outside the statute of limitations. So the statute of limitations is the amount of time a creditor has from the time an account goes into default. They have a certain period of time for them to be able to file a lawsuit against you. So, for example, in Arizona, it's 6 years. They have 6 years from the time the credit card goes into default. If they don't file a lawsuit within 6 years, then they're barred forever from doing it. So, what they're doing here is the Fair Debt Collection Practices Act, the FDCPA, states that if a debt is outside the statute of limitations, then the creditor, they have to put that little disclaimer on anything they send you saying, hey, we can't sue you, but if you want to pay $1,500, we'll make this all better, kind of thing. They don't really have any recourse. My guess is it's probably fallen off your credit at this point. It's going to stay on there for like 7 years. Maybe not. Maybe it's still on the credit. That would be the only reason, really, I think, to engage them is if you're trying to get it off your credit report. But truthfully, if it's over 5 years, it's probably not really impacting your credit that much anyway. And they're telling you right there they can't sue you. So there's not a whole lot they're going to be able to do to be able to pursue that. I'll leave it up to you whether you decide you want to pay it or not, but there's no reason to. They have really no recourse at this point. So, all right. Let's see. We'll finish with Mr. Laidback, 808. It says, after filing for bankruptcy, can the debt collectors come after you through the IRS? If so, how can you protect yourself? So if you file for bankruptcy and you owe taxes to the IRS, in most cases, they can still try to collect those. Those debts are called non-dischargeable. There are some exceptions. If the tax debt is more than 3 years old and you filed a return the year that the tax was accrued from, that it was incurred, and if it was, and as long as it hasn't been reassessed to you in the last 240 days, and typically the only way that's going to happen is if they go back and do an audit or something like that, or you filed an amended return or something, and then they reassessed it. If it meets those three criteria, if it's more than 3 years old, if you filed a return the year from the tax when it was incurred, and it hasn't been reassessed to you in the last 240 days, the tax is dischargeable. And so then no, they wouldn't be able to collect it. However, with something like this with the IRS, let's say it's from a year ago, you filed bankruptcy, it's still there. They can still pursue with collections. With the IRS, my recommendation is to reach out to them and deal with them directly. Ignoring the IRS debt is not a good approach. They do not go away. Well, they do go away after 10 years, but they can be aggressive. They can garnish. They can lien, and they don't have to sue you. They're the big bully in the room. They can do anything they want, and they don't have to go through the normal procedures. They can do what's called an administrative wage garnishment and just start taking your money. They can seize property. They can lien you. Another thing they can do, they can make it so you can't get a passport. You don't see that unless the amount is quite large, but they can limit that completely. So, all right. Let's see here. I'll do one more. I had my meeting of the creditors May 10th. Meeting of creditors is in a bankruptcy case. I live in California, and the trustee extended the hearing until April 12th because he didn't have my wife's tax return. My question is, can he sell her car? That is going to be very state specific. And I see you said March 12th. So that's very state specific. I don't know off the top of my head what the exemptions for vehicles are in California. The only way they're going to be able to sell the car is if you have non-exempt equity in there. I know California has 2 exemption statutes, and so I'm not sure which one that's going to fall under. If you have an attorney, I'd definitely bring that up to see if they can. If they haven't brought it up now, they may not, but it's something that they may do. So I am sorry for cutting it short tonight, and I wasn't even here last week. I was traveling, but I will be back next Thursday night. Go ahead and check out the channel. Check out the Consumer Warrior University. We've got a lot more people join there, and there's some good conversations going on. That's at the top here of the chat section. With that being said, we'll catch you guys.